Good morning. Happy Thursday. This quick video, I just figured somebody was making some comments in my comment section that I figure if this person is thinking it, maybe other people are thinking it too. The first thing that they were under the impression was that Adderley versus Florida gives the government unlimited and absolute authority to disallow people, that you don't have a right to be on government property and you don't have a right to film on government property, period. End of story, absolute. And they cited Adderley versus Florida for this particular position. And Adderley versus Florida doesn't say that. It says that the government can preserve the property under its control to its lawful purpose, which means that, you know, if a government is operating a piece of property as a post office, for example, they can implement laws or rules or ordinances or regulations or whatever to preserve that post office to function as a post office. And you always have a First Amendment right. Your First Amendment right exists, period, whenever you're within the territorial control of the United States. You have a First Amendment right. The government can limit that First Amendment right under certain circumstances. And it just depends on the circumstances. Either they have to pass strict scrutiny, limited scrutiny, or rational basis review. And on governmental property, generally speaking, the scrutiny that they have to surpass in order to be able to restrict your First Amendment rights is the rational basis review. They have to have a legitimate government interest, and whatever ordinance that they're passing, rule, law, whatever, has to relate back to that legitimate government interest. It has to, they have to be connected. There has to be a rational basis. It has to be rationally related to that legitimate government interest. It doesn't have to necessarily be the best effective or the least restrictive or whatever, but it has to be rationally related to that legitimate government interest. So it's not an unlimited thing that the government has. And in addition, if the government wants to trespass you from that particular piece of property, then they have to give you due process. They have to give you some sort of a hearing. It may be an administrative hearing, it may be something. There has to be some sort of a hearing in place in order to take away your right to be on that piece of property, because you have a right to be there. If it's open to the public, you're the public, there's a right to be there. And in some situations, you may not be able to be fully trespassed, period, like from a street or a sidewalk. The government may not be able to trespass you from that, at least not for extended periods of time. If they have it closed down for like a street fair or something like that, they may be able to close it off and only allow, certain people in. Oh, there's going to be drinking in here, so you have to be 21 and up. Or whatever, you have to buy a ticket to get in, whatever. But that's going to be a short period of time. They can't say, oh, you're trespassed from Washington Boulevard, forever. They can't do that. And also, if they do trespass you from places like, for example, a court or a police station, then they have to leave open. They can't just blanket trespass you from it. Like, they have to leave open if you come for legitimate business that is the actual business of that. Like, if you go to court to file documents in response to a lawsuit that's been filed against you, they have to let you in to do that, because otherwise they'd be denying you, again, due process. They'd be denying you the access to the courts, etc. And, police station, if you're going in there to report a crime, they'd have to let you do that, because that's the function of it. Again, they can restrict the access to it to its legitimate purpose. Beyond that, they're really limited. So, like something like a library, maybe they could kick you out permanently, but I don't want to really get into the weeds. I'm just saying that it's not an absolute, and the government has a burden of proof in order to take your right to be there away from you. The second thing was this commenter on the other video, on the I Hypocrite video. He said essentially that I failed to mention that Andrew Coffey IV and Kyle Rittenhouse's acquittals on self-defense were going to inform the McMichaels appeal. The McMichaels are, again, in the Ahmaud Arbery case. And they absolutely will not. First of all, they're in different states, so there's no bearing there. Sometimes on issues that are novel. If it's first time a particular state is looking at that particular issue, they may look to the other states to see what other states have done in that particular situation and use that to inform their decision. Those particular cases would be they wouldn't be precedential, but they might be persuasive. But what a state would be looking at would be appellate or Supreme Court decisions from other states, or from published federal court decisions. They would not be looking at trial court outcomes in other states, especially not jury outcomes, because the jury is just deciding a question of fact. The jury isn't coming up with some legal analysis, and there's no written opinion by the jury. Well, I guess technically they have their little cards they fill out that say, we the jury find XYZ person guilty or not guilty or whatever. But there's no written opinion. There's no legal analysis to look at. So absolutely not. Ahmaud Arbery's or the McMichael's appeal is not going to be influenced one iota legally by the Kyle Rittenhouse decision or the Andrew Coffey IV. Just so everybody's aware, Andrew Coffey IV was a convicted felon, but he was at home in bed. There was a pre-dawn no-knock raid, from my understanding. Just having seen, I didn't watch the trial. I just read a couple newspaper clippings on it. So I think that the sheriff did a pre-dawn raid. I think they were looking for drugs. Maybe it was a warrant issue, whatever. I don't know. But Andrew Coffey IV grabbed his gun because he was asleep, wakes up, people breaking in, grabs his gun, starts shooting, kills his girlfriend. So at trial, he gets convicted on a few things, like a felon with a gun, felon with a firearm. I think he got convicted on maybe something else. But the jury acquitted him of the murder based on the affirmative defense of self-defense. And self-defense, you can see the similarities between Andrew Coffey IV's situation and Kyle Rittenhouse's situation, because neither one of them went and provoked the confrontation. Unless you believe the prosecutors and Kyle Rittenhouse, which apparently no one does. But Kyle Rittenhouse was running away from Rosenbaum. Rosenbaum said, "I want to kill you," was running after him. There was another guy who was there who had just fired a shot. I mean, it was a tense situation. For those of you who think that we have to look at these situations in a vacuum, we don't. It was a riot. There were a lot of people there who were hostile towards Kyle Rittenhouse, and a mob, or even a single person. You can have a reasonable belief that a single unarmed human being can cause death or grievous bodily injury to you. And that's the standard. Do you reasonably believe that you are facing death or grievous bodily injury if you don't use deadly force in self-defense? And yeah, we've seen people get stomped in riots pretty hard before, and we've seen people get killed by rioting mobs before. Bare hands, people run up and kicking them in the head, like when they're down and things like that. It happens. It's a real thing. All the way back, Reginald Denny back in the Rodney King riots. Reginald Denny was a truck driver, pulled out of his truck and just beat the hell up by a mob. It can happen. Everybody doesn't have to be armed. It doesn't have to be shoot out at the OK Corral. You just have to have a reasonable belief that you're facing death or serious or grievous bodily injury. But Kyle was running away, and on every single attack, he was running away or he was down. Like he can't run away because he was on his butt. So he didn't seek out any of those particular situations. He didn't seek out. Yeah, he went to Kenosha. Yeah, he was there and he was armed, but he wasn't seeking out. He did not instigate any of those particular incidences. Andrew Coffey IV in bed did not instigate it. Yeah, maybe he had a warrant, or maybe he had led the police to believe that there was drugs there, but he did not instigate. He wasn't like, hey, I'm gonna roll my bed into the police station in pre-dawn hours and then start shooting because I want to kill cops. He was in bed. I mean, he wasn't starting it. But then if you look at the Ahmaud Arbery was running away. He was literally running away when three dudes in two vehicles that were armed roll up on him and stop him. At that point, he probably had an excellent case for self-defense because three dudes were trying to jack him at that point. Yeah, I mean, he should have started. I mean, if he was armed, he should have started shooting because you can't do that. So that's problem number one. Well, I think I've talked about several problems there. Number one, it's not a published decision. Number two, it's trial court level decision, not an appellate or a Supreme Court decision in all those cases. Number three, Georgia has its own case law on self-defense, when to apply it, how to apply it. I'm sure that statute, I think, was put in place in the 70s or something like that, or maybe earlier. So I'm sure they have plenty of case law on it. They don't need to borrow from other states' trial courts to try to figure out how to interpret their self-defense statute. So, and finally, the cases aren't analogous, but also finally, there is the real problem for the McMichaels that they did not have the privilege to commit or to conduct a citizen's arrest on Ahmaud Arbery. That's where it all falls down. A reasonable jury of their peers said, you did not have probable cause that he was committing a felony or fleeing from a felony. And without that, they did not have any privilege to arrest him. So what they were doing was not arresting him, they were accosting him with firearms, driving their vehicles at him, pointing guns at him. They were the ones who were wrong. So anyway, the Kyle Rittenhouse trial and the Andrew Coffey IV trial will have zero impact on any appeal that the McMichaels do. And, I wish the McMichaels the best of luck. I don't like to see people go to jail, prison, whatever. Oh yeah, one other thing. My understanding is that both in the Earl David Warden trial, both the prosecution and the defense have filed several motions, Brady motions, motions in limine, motions to include evidence, motions to exclude evidence. And those motions are going to be heard. So while there were pretrial motions set for the 3rd for Friday, tomorrow, and the trial was supposed to start on Monday, apparently the trial's been pushed out to February. But having those motions filed, having the evidentiary exclusions and inclusion motions filed, and theoretically they've asked for hearings on them, that is progress towards an actual resolution of the case. So we're going to see at some point this is going to go to trial, despite Earl's earlier protestations that it was going to be kicked out in a week. It does appear that it's going to go the full distance. So, I just guess we just all got to keep waiting. So anyway, thanks for watching. Have a great day.